appeal in the matter of Fairmont Property Developers UK Limited and Venus Bridging Ltd and others.
Good morning, Mr. Berg.
Good morning, my lady. I appear on behalf of the appellant, and my learned friend Mr. Morris is here for the respondents. Perhaps before I commence, I should make sure that you have the two bundles, the core bundle and the supplemental bundle.
And an joint authorities bundle.
And I just received out last night, and I handed it to your ushers, two historic authorities, in case your ladyship and your lords want to have some view of the historic background to this sort of line of cases.
Thank you very much. And if I can just tell you before you commence that we have had opportunity to read everything, and we consider certainly that this can be dealt with in half a day.
Very well. That's
Thank you.
Ambition, my lady. The significance of this appeal is not just for the ramifications that has been the law of mortgages, where the rights of mortgagors are fairly limited, well defined and limited, and beyond those they have very little relief when the mortgagee exercises his security, but also because specifically Section 91 has not really been directly dealt with by this court since 1993, and indirectly by Lord Justice Newbeger sitting on his own without benefit of both sides since 2005. The other point of significance is that since the decision of Cheltenham and Gloucester, to which I should take, my lady and your lordships, there has been some dispute or uncertainty about whether the court can exercise Section 91 in favour of a mortgagor when the mortgagee is taking active steps to sell the property. But I will be saying that, I'll be submitting that it can, if one applies the principles in PALC and mortgage finance properly. The judge below made three errors in the principal part of appeal, putting aside the expert application to which I shall come back at the end. The first one was relying upon the operative dictum of Lord Justice Millett in Cheltenham to hold that in a case of a commercial property like this, which was not part of Cheltenham, but a commercial property, where a mortgagee is taking steps to sell, and where, at least on the mortgagee's evidence, there will be a shortfall if its own sale goes through, one requires exceptional circumstances to intervene on behalf of a mortgagor under Section 91, and that in this case there were no exceptional circumstances shown. And then the judge went on and said that even if she's wrong about that, this case fails for two further reasons. One reason was that the appellant had failed to show any unfairness that would be occasioned if the receivers were to proceed with the proposed sale of the property at about £5 million. And that was wrong because the judge asked the wrong question about the value of the property and in fact narrowed herself to a single question. That single question was, is the property going to be sold at an undervalue on the balance of probabilities, to the exclusion of a number of other factors that she should have taken into account in the exercise of her discretion. And the third element of the judge's reasoning, which was an error, was to look in considering the potential prejudice that would be caused to the mortgagees if the order was made in the appellant's favour. She only focused on a very narrow matter, and that narrow matter was the possibility that the appellant would fail to sell the property and the receivers would have to try to sell it again. Now, that was not only a potential non-prejudice, meaning too trivial to be a real prejudice, but it didn't take into account the whole factors, which would have put that potential prejudice in context. I should perhaps say, before I go into my grounds, a point about the approach to take on this appeal. If this court sets aside the judge's order, then someone would have to re-exercise that discretion anew. Now, this court oftentimes does re-exercise discretions anew when it has all the facts in front of it. In this case, a difficulty may arise for two reasons. One is that since, my lady, your lordships have read the judgment, you may not have a full finding of all the relevant facts in front of you. For instance, the amount outstanding on the mortgage, the arrears to be incurred in the future, the means of my client to cover any shortfall. So those historic facts may require further inquiry, further investigation. Furthermore, because of the nature of Section 91, which looks at the effect of the exercise of that discretion on the parties, this court may take the view that it has to have the updated facts, not the facts based in February 2025, but the facts based in September, October, November 2025, to have to exercise that. So unless, following our submissions, this court feels confident that it can exercise the discretion based on those facts, but both parties would prefer that because it doesn't require then a further hearing. Otherwise, it seems to both of us that it might have to be remitted, albeit on a narrower basis, once this court has answered certain questions and narrowed the questions that have to be answered by a lower judge for some factual investigations to see what is to be done following from the judge's, setting aside the judge's order. Another small point on the threshold. My learned friend has made substantial references to a number of cases in this court and further up about the approach to be taken in reviewing the exercise of discretion. Now, without doubt, this was an exercise of discretion. It doesn't seem to me that there is any disagreement between me and my learned friend, perhaps some minor points. I will not take your ladyship and lordships to the cases. I will just cite them very quickly. It is to say that I agree with my learned friend that this is what is called a value judgment, where a judge has a fairly broad legal test and takes into account a wide range of facts and comes up with a composite decision.
What is the judgment that you refer to? I mean, the cases on value judgment are cases like, is an invention obvious? Is something reasonable, and so on and so forth? What is the judgment the judge came to, which you say is a value judgment?
The judge came to the decision whether it is just and equitable to make an order for sale. Just and equitable comes from the test set down by Park and Mortgage Express about when the court intervenes.
And I'm just wondering, is there any real distinction between describing that as a value judgment and describing it as the exercise of a discretion?
No, my lord. Really, all of this really comes down to saying that the judge should be shown to have been plainly wrong, or in the words of Lord Justice Asquith, quoted in G&G, that her exercise of discretion fell outside of the generous ambit allowed to a first instance judge.
And so it's an exercise of judicial discretion, which must be exercised having taken into account all relevant factors.
Yes. However, I would make it, and perhaps I would say that Lord Conworth, quoted in Sprint Room, paragraph 75 of that judgment, page 260 of the authorities, I would just say, summarize what Lord Conworth said those mistakes of discretion include. It can be an error of principle, it can be a flaw in reasoning, gap in logic, lack of consistency, but also importantly for ground 2 and 3 of this case, it is not taking into account relevant factors and taking into account irrelevant factors. And final point about this exercise, a review of the exercise of discretion, comes from the case of Graham, which was a review of a decision whether a director should be disqualified or not, and the director's disqualification. And Lord Justice Hoffman have set out two relevant principles here. That is, and I should say, all the references I make to page numbers are to the red page numbers in the authorities, not to the reported page numbers for consistency. At pages 80H and 81H of Graham, tab 5, his lordship set down two important guidelines. One is that where the standard is, the vaguer the standard it is that the judge has to apply, and the larger number of facts, the less reluctant is the court to intervene. At the other end, there are those instances where there is a specific threshold, for instance, whether someone has been negligent and the facts are not in dispute, and there the court is more willing to intervene. I would submit that this case falls in between the two, and there are two reasons for that. One is that the facts are not in dispute, or not substantially in dispute. There was no oral evidence, no assessment of credibility. The second point is that even though Section 91 gives the court an unfettered discretion, it has been based on a number of well-defined principles, which I should take your lordships, my lady, to. Therefore, it is not, for instance, a case management decision where it can almost always be case dependent on the history of procedural errors and so on and so But in any event, I'm confident that I can show this court that there was an error of principle that the judge did fall outside of the limits. I am planning on taking to an overview of evidence. I will try to summarize it to the extent I can. And the reason for that is that my submissions about grounds 2 and 3, but even ground 1, will then fall into place once the evidential background is in view of the court. Now, the reason for that is that both the judge and the judge found and my learned friend submits that this is an ordinary, yet another commercial repossession case. A property developer fails to pay the mortgage, receivers are appointed, they are trying to sell it, and he's trying to intervene. But that really was not, once the facts were revealed, the case. Now, this was a substantial property, 42,500 pounds of square footage, a warehouse outside of Milton Keynes. Substantial sums of money were spent,
Sorry, you said 42,500.
42,500 square feet.
Square feet. You said pounds, but you meant square
Yes, I did mean that. And all the valuations have pointed to the fact that it's generally in a state of good repair. It is very well located logistically in the middle of the automobile and transport sectors around Milton Keynes. On this specific unit, according to Mr. Vitale in his witness statement submitted part of the claim, he spent the company spent £1.5 million to refurbish it. And it has been let, the entire property has been let to Supreme Wheels Direct Limited, which is owned by a substantial refurbisher of alloy wheels. And the lease runs from 2020 to 2030. The rent under it was, until the March of this year, £360,000 per year. And on the quarter day in March, it rose to £371,000 per year. The rent is payable quarterly, £90,000 per quarter, the old rent approximately £93,000, the new rent.
That was not a rent review to market value, that was a rent review fixed in the original lease.
Yes. And the rent increase was itself a fixed increase to this sum.
I think some of the valuers say that it's actually under rented now.
Yes. The original value, meaning 2023, says it's slightly under rented. One of the valuations by the respondent says it's not under rented, but the second one says it's under rented. The second one says at the time, in September 2024, the market rent, in his opinion, was £400,000, so £30,000 more than the current rent. There's a prior charge. At the time of the appointment of receivers and the claim, the property was charged a first ranking charge to Coutts for the value of £4.1 to £4.2 million. The fixed term of this mortgage, meaning the second ranking mortgage, which
That's presumably the same because the rent covers the interest to Coutts.
No, my lord. The rent has been kept by the receivers. In fact, Mr. Vitale stopped, or the appellant stopped paying rent about a quarter or two before the receivers stopped paying the interest to Coutts a quarter or two before the receivers were appointed. In his opinion, in his evidence, he says that he did so because Coutts were told that the charge would be redeemed upon sale of the property, and the sale was imminent. Therefore, Coutts did not take issue with the fact that the interest was not being paid. And in fact, with some minor payments, about £20,000, Coutts' charge has not been, its interest has not been paid since, so it's been in arrears. However, both at the time of the claim and to date, they have not taken any steps to enforce, and in fact, they were offered to be joined to these proceedings, and they said, we do not wish to be joined to these proceedings.
So do you have a figure for the current redemption?
Yes. The current redemption, which was submitted as part of the evidence in an application made recently to this court. The current figure, at least as of August, it was 4.420 million.
Okay. Well, we've gone up a bit since then.
Well, interest accrues quarterly in arrears. And if I recall, my lord, it's the next tranche falls in October. So it could be that in
So
October.
it should be the same now.
Yes.
Thank you.
When the receivers were appointed, Venus, the respondent, first one, was owed about £900,000. By the time of the claim, it was £941,000. Therefore, taken together at the
You
time.
said by the time of the claim, when was the claim brought?
The claim was brought in the early part of December. Was it the 5th of December?
Thank you very much.
At the time of the claim, 5th December, taken together, approximately, the property was encumbered in the sum of £5,137,000. Now I come to the source of the dispute in this case, and what
But before you do that, you said it's wrong for the judge to say that this was an ordinary commercial dispute. And you said, look at the evidential basis. You described a situation where there are two charges and a lot of money owed and they're in default. Isn't that relatively ordinary? I'm not a commercial lawyer, but that sounds like something very ordinary. to
so
me.
far it is extremely ordinary,
Yeah.
and I would accept that. It is really now that it becomes maybe slightly
Oh, right.
more extraordinary. But the source of the issue is, if I could take, my lady, take you to the supplemental bundle, page 121.
I'm sorry, I didn't hear the page.
121.
Thank you.
This is the advertisement from October 2024 that was posted on behalf of the receivers when they were appointed. That shows a picture of the property. On page 123, it boasts of the low capital value at which the property is being marketed. That's the very last item. Low capital value of 112 square foot overall. And at the very last page, 130, it speaks of an attractive yield, or what is called an net initial yield, N by Y, of 7.34%, and a sale price of 4.75 million.
It's this paradoxical thing which I always find difficult. The higher the yield, the lower the capital value.
That is correct, madam. Yes. The yield is arrived at by dividing the value of the property, or the sale price. Well, sorry, the annual rent. Usually the annual rent, sometimes it is a reversionary rent, but in this case, the annual rent divided by the value of the property. Or the other way around, for people who sell, it is to come up with a yield and then take the rent multiplied, well, reverse multiplied by the yield and come up with the sale price. So in this case, based on the old rent, or at the time the current rent, now the old rent of £360,000, the yield of 7.13, one comes up with an offer price of 4.75. Now this is the source of the alarm to the appellant, or was the source of the alarm to the appellant, and the reason for it is that there was a history up to this point of the property both being valued and being sort of marketed and gathering potentially interested buyers for a much higher sum. The difference essentially being between leaving a deficit, if sold at this price, a deficit of £400,000, and a surplus of potentially £2 to £3 million. If I could therefore start with the first and maybe the most important valuation, which starts on page 71. and it is of the same bundle. Send it to one of the supplements.
And this was before the judge.
This was before the judge.
Mm-hmm.
I will summarize some of its basic findings perhaps more quickly to focus on the more important parts and make better use of my time. This was commissioned in February 2023 by none other than the respondent's predecessor or the agent, the security agent. So it wasn't done by my client, but it was done by the other side, February 2023. It describes the property as a good investment and says there's good demand for it. It describes the marketing period of 6 months. That's on page 74.
Where does it say good investment in 6 months?
It is under the heading of saleability of property.
6 months, I see that.
Yes, and above that,
Strong investment.
strong investment. In a very popular logistic warehouse light industrial area. The one issue that it identifies is the break clause that comes into effect in March 2025, although a 6-month notice should be given, so it would have had to be exercised in August, September 2024, which in the event it wasn't. And that is summarized, page 75, in what the industry, I think they call it a SWOT, or they pronounce the SWOT analysis. The weaknesses, the first element of the weakness is the short-term uncertainty about the lease. And another point of uncertainty is at the very bottom, the fact that the rent increase is fixed. Now, the last one remains the case to this date, but the first one has gone, or by the time the receivers were appointed, was certainly gone because the tenant had said that I'm not going to exercise the break clause. Page 92. Rent is described as being slightly below market.
This is still the same document.
This is the same.
Mm-hmm.
So the per square footage rent at the time was 8.48 for this property, and the surveyor says in the market is between £8.5 to £10. The crucial part starts on the next page, page 93, where the surveyor comes up with some comparative evidence, or comparable evidence. And on the next page, perhaps I should point out, on the analysis, N, I, Y are the net yields for those properties. One can see that the first one is quite high, but also one can see that the rent is much lower. So the area of the property is comparable to this property, but the rent is at the very least £120,000 per year lower. But the other properties have a yield of less than 5%. In the next page, in the very last box where it says market value conclusion summary, the surveyor concludes that a net yield of about 5% would be the appropriate one for this property, and based on that, well, it is said there that based on that he comes to the conclusion that the property is worth £6.74 million. But there's a small caveat about this valuation, and that comes out on page 119. Perhaps difficult to read. But one can see here that the valuation of 6.7 is after the deduction of all the costs of sale and stamp duty and all of those sort of things. So the actual value of the property based on a yield of 5% is £7.2 million. Also before
Sorry, I
yes.
can't find the 7.2 figure. on the thing.
Yes, my love,
Gross valuation, third down.
it is the very top gross valuation. Below the date,
Which page? Sorry.
119.
Thank you.
And this is as at 24th of January 2023.
Yes. Also before the judge was evidence of previous interest shown or offers made on the property. They started on 131. I will not take your ladyship and my lords to all of them, but an example of them is 131. It's an offer made in a year earlier, in January 2022, on behalf of Capital, a large investment fund.
None of these ever resulted in a contract. These were non-legally binding expressions of interest.
Yes, the closest they came to, my lord, was heads of terms signed with Haybridge on page 138.
They were subject. They must be subject to contract because we were told in the evidence that there was a change of government in Brazil and things went haywire, and it didn't translate into a contract. So that was not a contract either.
That is correct. No binding contracts, but there are indications of where market interest in a non-committal way, if one can put it, Lois, was about this property in January 2022 or March 2022, which is the heads of terms. Following the commencement of the claim, the receivers and Venus put in their evidence, or the evidence upon which they had relied. Two of them are quite short email marketing advice by estate agents, but there are two Red Book valuations. One of them is by Newman and Webb, made on the 30th of September 2024, on page 215 of the same bundle. I will summarize what I consider its main findings. There's the same praise about, or the same findings about the location and the quality of the structure. And that is on page 220, section 2.5, and 221, section 4.5. I will pause whenever your lordships, my lady, want to look at this specific point, but I will go a bit more quickly over this. There is no indication in this report that anything substantially has changed in the market since the last report, and the last report, I should say, had mentioned there's volatility, there's inflation and rising interest rates. According to this report on page 218, rent is at or slightly above the market rent. One can see market rent has £370,000 per year given by this surveyor.
Sorry, which page?
218. It is paragraph 1.12 of the report. And now that we are there, one can see the conclusions of the surveyor at point 19, which is that this property has a market value with the existing tenancy of £5.3 million. Now, the way in which this surveyor comes to that conclusion is on the basis of a net yield of 6.75%, as opposed to the 5% of the previous report. And that is done on the basis of comparative properties on page 226. Starting with the heading Industrial Investment Sales. There are 3 properties that the surveyor has found as a basis of comparatives. One can see that one of them is at 5.4%, that's the first one. The second one, 6%, and it's only the third one that is close to 7%. So it is really the third one which the surveyor has found to be perhaps the most comparable and therefore the basis for the yield that he's proposed. I would only say about this that the rent is much lower than the current one. It's about £7 per square foot as opposed to the 8.5 per square foot of this property.
So this 13.4.11. So what do I get about? It's the same size, roughly 42,000 square feet. The yield is 6.95, but the property sale for 4,050,000 in September 23. So what am I getting out of this? Is this the one that you say is the relevant one?
That is the one which the expert or the surveyor must have found the relevant one, because the other 2 have much lower yields. He doesn't expressly say that, but that is the only way in which one can make sense of how he came up with such a high yield for this property. Must be that he thought the third one is somehow the more relevant one, because the other 2 are in fact much lower. And in fact, if one bases the value of this property based on those other 2, under all of them, the value is at least £6 million and can go up as far as £8 million, depending on which of those other 2 one picks. Now, this is important because before the judge was not so much the question of rejecting one report and saying the other report is better. It was to understand whether, if this sale went ahead, there'd be a real risk that it would be at an undervalue. And as part of that exercise, the judge should have taken a view of the basis upon which these valuations had been made. Because once one does that, in respect of this report and the next one sees that they're quite conservative based on their own evidence. Now, that doesn't make them wrong, but that makes them quite conservative. As I stated earlier, the valuation of £5.7 million in this report is based not only on a very high yield, but it is also based on the rent that was soon to go up. Had the same yield, the same very high yield, been applied to the new rent that was due to come in March, that in fact was about to come in when the judge was hearing the claim, the value of the property would have been £5.5 million. That may not be as high as £7 million, that was the earlier report, but that is still £750,000 higher than the sale price.
Well, I thought it was offered in excess of 4.75 million.
Yes. In fact, by the time of the report, by the time of the claim, receivers had found the purchaser for about £5 million.
Yeah.
So it would have been £500,000 higher than that offer. It still would have been a difference between a surplus, albeit not a substantial surplus, nonetheless a surplus, and a deficit.
You said a little while ago that on these yields you could get up to 8 million.
Yes, not on the yields, my lord. I misspoke. On the square footage of the property at 13410, which went for £195 per square foot. If one multiplies that by £42,000, which is the size of this property, one gets to 8.2 or 8.3.
Is that of any assistance?
It is.
These are investment properties that are already let.
Yes.
The way in which you value an investment property is you find a yield and then you just plug that into the amount of passing rent. You obviously take account of the strength of the covenant and the likelihood of the lease running to its term and what the reversionary interest is and so on. But the primary way of doing it is how much is the tenant paying and how many years purchase do I get?
I accept that, my lord. In a property that is tenanted, the primary way of its yield is of its value is the yield. The per square footage might have some relevance where a property is empty or where one wants to compare its rental potential with some other properties. So I accept that, my lord, and that's why.
I don't find the 8 million figure a particularly helpful one. If you apply the net initial yield of 5.4% to the passing rent of 360,000, I don't know what you get, but it must be somewhere around 6 million-ish.
It would be above, because when I have multiplied 6% by the rent, by the old rent, I have got £6 million. So if one does less than 6%, it goes,
you get
yes, more than 6 million, but certainly at least 6 million. So I certainly accept, my lord, that the more important indicator is the yield, and that's why I focus on the yield. I would be briefer with the second valuation by the receivers. It comes to the same price or the same valuation by the same conservative approach, which doesn't make it wrong, but does make it a very safe valuation. Starts on 238, and I would really take your ladyship and my lords to page 271 because that's where the comparables are.
So which page?
271.
Yeah, thank you.
As one looks at the yield on the right-hand side, one should keep in mind that the yield to which this survey arrives is 6.75, like the previous survey. And one can see that all of these comparables, bar one, which is at the top of page 271, insofar as they have a yield, insofar as they've got a tenant paying rent and therefore can generate a yield, they all have 6% yields. And it's only the one on top, in Connex 90, as it's called, the address, which has got a yield above 7%.
Well, that's more than double the size anyway, isn't it? So
Yes, my lord, it's more than double the size.
5 million wouldn't be not comparison then.
Yes, and more than double the size, and the rent is, well, the rent is actually not so bad. It's £9 per square foot, but it is double the size. The more relevant one, in my submission, is the one number 3. It is at the bottom of the same page. Again, it doesn't have a yield because it was empty and in fact unrefurbished. But it's in the same estate, it's the same size, and it's sold for £6.5 million as an empty and unrefurbished property. One can see the surveyor's calculations on page 274. There are 2 points to be made about it. One is it's based on what is now the old rent. At the time it was the current rent, but when the claim was being held by the judge, it would soon have been the old rent. And it includes a deduction of, well, purchase cost of about 6.5%, but the gross value is 5.3. Using the same yield again on the new rent, or soon to be new rent, one again comes to a valuation of £5.5 million.
Sorry, how did we get that?
Lord, what I have done is to take the yield of 6.75%, which is what the surveyor has relied upon, and computed into it the rent of £371,000 as opposed to £360,000.
Can I just be sure what we get from page 274? So you've got the passing rent is 360,000, 6.75%. That gives you a figure of 5.3 million.
Yes.
You then allow for purchaser's costs. What's that? Stamp duty and the like.
I couldn't find a breakdown of what these costs are, so I cannot help you, my lord.
But does that mean that when it says market value, that's the actual sale price? A purchaser would only pay 5 million because it would cost them 300,000 to get the asset.
My lord, I should admit that I struggled with this because it suggests that the gross value is 5.3, and therefore I would have thought that it means one puts the property on sale for 5.3, and perhaps one gets at the end of it £5 million. But somehow,
Well, I'm not sure that is what it says. I think it says if the purchaser wants to buy an asset which will be valued at 5.3 and has to pay 300,000 in costs, i.e. not going to the vendor, which is largely stamp duty, the purchaser will only pay the vendor 5 million. That's how I read it.
that could be a way of reading it, yes.
That seems consistent with the next page, actually.
Yes, under 13.3. My lady, you may have seen in the papers, I will not take you to it, but I'll make reference to it unless you would like me to, that in the run-up to the appointment of receivers in the summer of 2024, Mr. Vitale was in contact with his estate agent, Mr. Nick Harvey, and albeit this is, again, non-committal, extremely informal evidence, Mr. Carvey was writing to him and saying that he was in discussions with various potential investors, and the sums that they were discussing were above £6 million. And those bits of evidence start from 147 in this bundle, and they go to 158.
But again, they came to nothing.
Yes. Now, Mr. Vitale states about the last bit of the discussion, which was taking place on the 17th of September 2024, which is 3 days before the receivers were appointed, that as soon as those parties saw the receivers being appointed and the sale price, but they had no reason to come and offer £6.4 million. The receivers have said in their evidence that we have got no evidence of these parties and they were not referred to us. That is what the receivers say. To summarize the source of this dispute, it is that on the evidence that the mortgagee itself had acquired, and on the very informal and non-committal, albeit heads of terms in one instance, the property was certainly seemed to be worth at least £6 million, by some measure more. And then the receivers were appointed, and this brochure comes up, and that is quite shocking to someone who, perhaps rightly or wrongly, but thought that this property was at least £6 million, if not £6.5 million. The other significant point about these evidence by, or valuation evidence by the receivers, is that they never really discuss, or let alone mention, that there is this other report done by us. And how do we reconcile the fact that Atchison and Rafferty, who were then contracted to market the property, thought this property was over £7 million a year ago, and now this year it is worth a third less. There's no engagement with that. But the point before the judge was not to prefer one expert to the other. It was to form a judgment about what the risks and therefore the potential injustice was. And the correct conclusion based on this, without rejecting anyone's evidence as being incredible or weak, is to say that the price at which the property was being marketed was even more conservative than the conservative valuations on which it was based. So 4.7.5 being marketed for, or offers above, 5.3 million is 5 to 5.3 million is what the valuations are saying to the receivers. And if one calculated the new rent with 5.5 million, that is the landscape in which this claim happens.
Excuse me.
Can I just pick up that point? You said if calculated on a new rent, it would be 5.5.
Yes.
I think you said this before. That's a figure which it's not to be found in the report. It's derived by applying the yield of 6.75% to the 370,000 figure.
Yes, my lord. And that was part of my submissions to the judge. When one looks at those reports, one has to keep in mind how cautious they are about the valuation. If one remembers that they would have known that in a few months' time the new rent would be coming in, and any investor would have had that in mind when they were paying a price.
So I read the Hanway report at page 274. They've taken account of the fact that the rent is going to go up to 370,000 in reaching the figure of 6.75. That's after considering suitable adjustments. Third paragraph up from the top.
Sorry, which page are you on?
I'm sorry, it's 273.
Yeah, thank you.
After considering suitable adjustments, we come up with a figure of 6.75%, reflecting the fact that the tenant break clause has not been instigated and that there is a fixed increase to 371. So I'm just wondering how valid it is to take the 6.75 as if that is simply the yield that can be applied to 370,000, because it looks to me as if what they've done is they've taken account of the 370,000 in adjusting the yield to reach the 6.75% figure.
Well, look, I suppose that argument, the consequence of that argument would be that if the rent were not increasing, they would have said the yield is even higher. They would have said the yield is in fact 7% or 7.2%. But because the rent is increasing, we have adjusted it a little lower. That is one potential way of looking at this. The more plausible one to me is that if they intended to take that into account, oftentimes what these valuations do is to apportion different yields or use different yields or come up with composite yields based on two different rents. But at some point, the new rent would have been taken into account either at the yield point or the post-yield point. And in any event, one looks at the comparable properties and one says that, well, the fact that this property based on the new rent should have a yield of 6.75% makes it even cheaper than it would have been based on the comparatives, because the rent would have been higher.
Thank you.
So the respondent's position going into the hearing was not so much that they said that this is the value of the property. They said we have taken a price and we're relying upon this price. And furthermore, they say, and this is Mr. Vasani in his witness statement on page 107, paragraph 23. I'll just summarize what he says. What is on, sorry, it is in the core bundle, page 107, paragraph 23.
Paragraph 22.
23.
Thank you.
Can I just check? I thought Aitchison Rafferty, who seems to be saying in 2024, put it on the market at 4.8 they're the ones that prepared the report a year earlier.
Yes, that is one of the interesting facts of this case.
And
And
just remind me, who did Aitchison Rafferty prepare that report for, and for what purposes did he prepare the 2023 report?
they prepared it for Market Financial Services, which is a security agent for Venus and Venus's predecessor. So it would have been for the purpose of refinancing
To check whether they could lend that amount of money on
Yes.
that property.
and to see what the value of the security was if they had to enforce the security.
And your client wanted the money for other projects, not to buy that
He was
property.
refinancing.
He was then trying to get planning permission for other projects.
Yes, and also he was refinancing a previous loan on this property. So there the receivers describe the marketing strategy, and they say we decided to pitch it below the value to drum up sufficient interest.
I'm still stuck on this. If there are three figures, the in excess of 4.75 million, the 5 million or thereabouts from Newman Webb and Handway, and you're referring to a number of things, non-binding expressions of interest, and the 2023 report.
Yes.
But the 2023 report was provided by the same people
Yes.
who were saying a year later it's actually 4.8 million.
Yes, so the same entity, perhaps different
Yes.
persons, but that is correct, my lord. And as I submitted earlier, it is quite a remarkable fact that no one seems to have mentioned the previous report, even to acknowledge it or to say what has gone wrong. Because if a property's value drops by so much, it should raise alarm bells. Someone should try to explain what has happened, because that is that would have serious consequences for both parties. But no one really seems to mention it, as if this report doesn't really exist. In fact, my learned friend doesn't refer to it in his closing argument as one of the pieces of evidence on which the appellant relied. He says the appellant had opinions and aspirations about the value of the property, but they were based on reports commissioned by the respondent. The receivers described their strategy as putting it at a lower price to drum up sufficient interest, as they put it. If the judge had referred to the expert report that was put in front of her, that is the expert report of Mr. Ferris from January 2025. I should come back to it later, but Mr. Ferris essentially says that unless one has an auction or an auction-style sale of a property, putting it at a low price in the hope that it rises as bids are made is unlikely to come true. And he states that the usual strategy for sealed bids or by private treaty is to pitch it at a slightly higher price and then negotiate it down. But the receivers picked the opposite strategy. And the fact that it hasn't really worked is proved by the fact that by the time of the hearing, they had only received, the best offer they had received was £5 million, which is the lower end of their own valuations. I would mention this very briefly on the point of valuations, and I will move on, which is that the appellant had commissioned for the purposes of the claim and filed it with the claim itself a report by Mr. Ferris from November 2024, which was then updated and turned into the expert report later. It is in the supplemental bundle, page 161. I will not take your ladyship and my lords to it, but it then comes up with a valuation of over £7 million.
Was that in evidence before the judge or not?
Yes.
That one was before the judge.
Yes. As I was saying in the expert application part, one of the consequences of the judge's decision refusing expert report was that she had in front of her 90% of the expert report in the form of the Red Book valuation, but not the 10% about the marketing strategy. But it was before the judge.
Can you give me the reference to where that is in the supplementary bundle again?
To the report.
I think you said page 161.
That is correct, Mayor. This is 161, and the crucial part talking about valuation is 188 to 189. Mr. Vitale made, the appellant rather, Mr. Vitale being his sole director at the time, made this claim, therefore asking for an order to have conduct of sale. And in the claim form, as well as in his witness statement, he said, well, I'm asking for 180 days because I believe 180 days allows enough time to have a fresh approach to sale. But there is mention, because I know my left hand has taken issue with this, there's mention of alternative orders. Shorter period of time or at least a minimum price for a period of time. So the receivers could continue to sell, but at a minimum price. Now, I turn to ground one, but because I've taken you, my lady, I've taken you to the evidence, I can deal with it more quickly. Ground one deals with the exceptionality point. In the core bundle, page 65 is where the judgment begins. At paragraph 6, the judge looks into the wording of the statute. She does say that that is not the basis of my decision, but she states that, in the purpose of reading of the statute, it doesn't seem really to be designed for instances where there's a competition over who should sell it, but rather it seems to refer to cases where the mortgagee doesn't want to sell it, refusing to sell it. But then she moves on from that point. Paragraph 7, she deals with park and mortgage services funding, which is the crucial case in this line of authorities, the crucial modern case. But the way Mr. distinguishes that case, not fully but perhaps partially, is to say that it was dealing with residential property and should perhaps be dealt with a particular caution. I would be submitting that there is nothing in park that seems to suggest it's limited to residential property. The facts might sometimes differ, but the principles.
She doesn't say it's limited to.
It said it's about residential property and it should therefore be treated with a degree of caution.
Yes, and I do not think that they cannot be applied in a commercial case, but the factual matrix is relevantly different. That's all correct, isn't it?
Yes, what I would really say, my lord, is that it should not be treated with a degree of caution, but it should be embraced. It is crucially at paragraph 8 and 9 where the judge turns to Cheltenham and Gloucester and Krause. The judge refers to the opta dictum of Lord Justice Millett, to which I shall return later, where his lordship expresses his misgivings or caution about whether the principle in Park, which I shall come to, should apply to two instances or two combined instances. One is where the mortgagee is taking active steps to sell the property or to obtain possession and sell the property. And secondly, where this is a slight rephrasing, maybe it's a crucial rephrasing of Lord Justice Millett's dictum, where on its evidence, as the judge put it, meaning on the evidence of the mortgagee and the receivers, there was going to be a negative equity. In paragraph 9, she combines those two considerations with submissions by my learned friend that in Part 8 proceedings of this kind, it's not appropriate to make decisions of this kind where there is a difference of evaluation. And combining these three, turning to paragraph 10 and 11, the judge holds that because of those three factors, she should be slow to interfere with statutory and contractual rights. Well, I cannot object to being slow to interfere with those rights. But in paragraph 11, she states that exceptional circumstances are needed and none exists here.
Well, you've got to read 10. She says, the situation is the mortgagee has got statutory commercial rights. The mortgagor is in default. Receivers have been appointed. And the mortgagee is entitled then to sell the property. That's the situation that applies. And when she says exception, isn't she simply saying we need something to say we shouldn't follow through the logic of what normally happens?
Yes, my lord. In my submission and the way Mr. Judge went wrong is to hold that that is the conclusion as opposed to the starting point of the application of the Park principles. I shall refer to them as the Park principles. It seems to me that they're not really principles in Park, they're what the statute says. But as the Vice Chancellor and Sir Michael can make it quite clear, the very purpose of Section 91 is to intervene in between contractual and statutory rights of a mortgagee. So far from being the conclusion of the judge, that should have been the starting point. Of course it is an intervention. But is there an unfairness? Is there a prejudice that justifies it? That should have been the approach. And in fact, that is what then the judge goes to apply. But this might be the right time to refer to the case law. I have cited, I have belatedly brought to your Lordship's attention 2 old cases, and I will just talk about them very briefly. The first is Warner and Baker, a decision of Mr. Justice K. And it is not based on this statute or its predecessor, which was the incident. However, that is a case where a mortgagee thought that the mortgagor was selling, a mortgagor was of the opinion that the mortgagee was selling the property at an undervalue. It brought a claim. There is no statute referred to, so it must be an equitable claim. One is for a decree of redemption, and the other one is to stop the sale. This case is well known for its statement of the nature of a mortgagee's exercise of power and the fact that it is not a trust, it's not a power exercising the benefit of the mortgagor. But there's another element of it that points to how limited the rights of a mortgagor were before the statute came in. Page 223 of the printed of the reported case. I apologize, 224. The part that has a line which unfortunately is black and white, my fault. The judge summarizes the authorities on when the court can stop a sale of a mortgage property where there is no breach of a duty by the mortgagee. And those segments are extremely limited, and they require a mortgagor to pay into court total sum to redeem the mortgage.
Which bit are you relying on?
Yes, my lord. It is in the middle paragraph, starting, his lordship then said.
So you've got the first bit that says they wouldn't normally interfere, even though the price is low, unless it's evidence of fraud. But then he goes on to say what?
Yes, so he says, his lordship then said, and by lordship he refers to the Vice-Chancellor Stewart in Robertson and Norris, said, the writ in this action was issued, no tender of mortgage money having been made, nor any attempt to stay the sale by injunction, which according to authorities I have cited. I apologize, what is meant by his lordship is actually Mr. Justice K. This is what he said. He says, the writ in this action, meaning in Warner and Jacob, was issued, no tender of mortgage money was paid, and no application for an injunction, which itself would have required tender of mortgage money. And in those instances, the court would not stop a sale, even if it's a potential undervalue.
So I don't understand how this helps you, because if you read down, what it seems to be saying is that unless there's some element of bad faith, the mortgagee is entitled to redeem his debt.
Yes, so my lord, the submission here is that when we look at Section 91 and its predecessor, it should have tried to make a difference in the law as it stood. And the law as it stood was quite limited. This was the law as it stood. The next case, which I referred belatedly, is decision of Mr. Justice Chitty, Merchant Banking Company of London, 1886, reported in the Times Chancery Division. It is mentioned in Park Mortgage Express. It is based on Section 25 of the Conveyancing Act 1821, which has the Vice Chancellor in Park states is in terms similar to this. So we're talking about the same statutory power. Now, this was a case where the first mortgagee was foreclosing the property. They brought an action for foreclosure. And the second mortgagee, with the support of the mortgagor, had made an application on the equivalent of Section 91 to have an order for sale of the property. The basis of that was that an Act of Parliament had been passed, the Manchester Ship Canal Act, and it was thought that this would lead to a rise in the value of the property, and therefore the property should be sold so that one can capture the surplus and pay second mortgagee and maybe the mortgagor. Now, that application was rejected by Mr. Justice Chitty. And the reason why it was rejected is on the next page, at a very small, short judgment or a summary of the judgment. The factors were the security was insufficient. So on evidence before the judge, it's been proven that the mortgagees, the first mortgagee's security was insufficient. It had no further protection, is what the judge says. And on the evidence before the judge, the sale was very speculative. The other factor that played in the judge's decision was that the first mortgagee had offered the second mortgagee to have the first mortgage, to buy out the first mortgage, and then if it wants to speculate on the sale, it can do it itself. And the second mortgagee had rejected that. That was another factor. So it was that the sale was speculative, the first mortgagee was unprotected, and the second mortgagee had been offered an option which he had rejected. And in those circumstances, the application was rejected. Instead, however, an order for foreclosure was made to come into effect in 6 months' time. So that must still have given the parties time.
So the end result is that the first mortgagee did foreclose and they did get the property.
Yes.
And the second mortgagee
Was-
wanted to sell it rather than have the first mortgagee, couldn't do that.
Yes. Of course, the effect of...
Does this help here?
It doesn't help me,
Oh,
I just
right.
want to say yes. To make it clear. Although perhaps in a more fundamental and philosophical sense, it does help me, because as early as the golden age of Victorian jurisprudence for contract and rights, there is this weighing of the factors, which then gets its full expression. By factors, I mean weighing of the unfairness and the prejudice and how speculative and whether the mortgage is being protected. These factors that are given their full expression in Park and Mortgage Express.
That's how I understood your reference to Mr. Justice Chitty's decision, although it's only one paragraph. He's weighing up the factors in the favour of the various parties, or the detriment to them, or the benefit,
Yes.
and concluding where the balance should lie.
That is my submission.
Mm-hmm.
Now,
And you're taking us to PAL.
Yes, PAL. It is treated as the modern authority, and the reason it's been treated as modern authority is that the practice had been that Section 91 would only be exercised where it was sure that there would be that the mortgagee would be paid in full, either because of the tender of money into court, or more likely because the price would be fixed at such a level that it would be sure that it would be paid. What happened at Park was that the court made an order where it was certain that the mortgagee was not going to be paid its debt in full, and the mortgagee opposed the making of that order. That is what makes Park a new chapter in the exercise of Section 91. But in my submission, the principles upon which it is based, and the judges are quite clear that the principles themselves are not innovations, that the facts are new, but the principles are not, are principles that can be found in the wording of the statute itself, which gives an unfettered discretion, and in fact can be traced as far back as the way in which Mr. Justice Chitty was treating that case before him. Now, starting tab 4 of the authorities bundle, page 54 is where Sir Donald Nicholls' judgment, as it then was, begins. I will go through it in the order in which he said it, and I will just pause at the crucial parts. The statute is set out at page 55, section H. Next page is where His Lordship goes through the history of it. The very origins of this power lie in section 48 of the Chancery Amendment Act, 1852. But that was only at the suit of a mortgagee trying to foreclose that he could get an order for sale. What changes is with section 25 of the Conveyancing Act, 1881. It is important to see what Sir George Jessel, as far back as the late 19th century, said about the predecessor section 91. That's on page 56. section F. He refers to the power as a remedial one to be liberally construed, and the court has the power to impose terms so to take care that no injustice shall be done to anyone. Then from section H to D, the old practice is referred to and summarized. I will skip it because I've discussed it already. The new problem, as Sir Donald Nichols refers to, arises in this case, where the mortgagor was being forced by the mortgagee to hold on to the property so that the mortgagee could rent it at a low rent in the hope that at some point in the future property prices would increase and then it would sell it. Whereas the mortgagee wanted to get out of this ever-mounting debt and the property and to sell it, albeit to sell it certainly at a price that would have left a deficit. On page 58, all the way to page 60, Sir Donald Nichols talks about the duty of fairness that the mortgagee has to the mortgagor. But the crucial part about that discussion is on page 60, between just above section D. And it is that the exercise of section 91 does not depend on some breach by the mortgagee. The judge says that it might be a factor to take into account, but it importantly does not require a breach. Now I submit that that is crucial as we come to assess the nature of unfairness. It doesn't have to be an unfairness that gives rise to a cause of action. And then under the heading, the court's discretion. This is from which I distill what I would describe as the test that was applied in PAUC, albeit I would accept that one should not limit an unfettered discretion to a single test, but it's a useful way of trying to give discipline to a discretion that otherwise can be exercised on just and equitable grounds. In the first part, meaning above section F, His Lordship talks about the unfairness that would be occasioned to Mrs. PAUC if an order were not be made, and if she were to become, as it were, the subject of a speculative move by the mortgagee in the hope that the property...
There's going to be no sale here because they won't sell it, but the debt is going to be going up and up and up. There's nothing she can do unless it's sold.
Yes, yes. And even then, of course, there will be a debt remaining, and then she will be sued on the personal covenant, but that's by the way. The second part of that, what I would call the test, is between G and H, or rather around H. The second notable feature is the primary objective of the company can be achieved without Mrs. PAUC being compelled to become an unwilling risk taker. That is to say that if an order is made, the mortgagee does not suffer a prejudice because it has its other option if it wants to take it. And then it's on the next page. That in broad terms, the power is described. It's an unfettered discretion, certainly A, should be exercised having regard to the interest of all concerned. And importantly, the court should not decline to exercise it if the consequence is manifest unfairness, or to put it the other way, if there is unfairness that can be cured by an exercise of section 91, then subject to what I say next, the court should consider exercising it. Then the four factors in the specific case are discussed between B and E, and they are the matters that I've already referred to: the fact that the debt is going up, that she wants to be got rid of, and the fact that the mortgagee has other options. At the very bottom, coming back to the statutory powers, His Lordship states that this is not an unjustified interference with rights of the mortgagee, because those rights are given by statute, although they're also given by the contracts of mortgage in most modern cases. And this itself is a statutory power. So is it where the same hand that gave the right has also given the power to interfere with it? At the next page, I should turn to the judgment of Sir Michael Kerr. At the bottom of page 62, His Lordship identifies two distinguishing factors about this case, or what appears to be distinguishing factors about this case. And one is, the first one, crucial to this case, whether the court can exercise the power or make an order against the wishes of a first mortgagee. And the second crucial feature of that case was the fact that if that power is exercised, there will be a large debt left unpaid. I summarize the principles that I get from the next page, meaning page 63. And it is that the power, the exercise of the power, does not depend on the mortgagee taking enforcement actions. That is between A and B. Now, surely that must include its right to sell. It would also include the right to appoint a receiver, the right to take possession, to collect rent, but it must include the right to sell. The judge does not make any distinction between that and other rights. And the second part, again, B, is that it can be exercised despite dissent and objection, even if that dissent and objection is based on contractual rights. But the power is then limited, and I would submit that these are sufficient protections to make sure that the floodgates are not open to every mortgage or homeowner, property developer who's got a slight disagreement with a mortgagee. One has to be fair to both sides. One must do what is just in all the circumstances. And importantly, as part of this exercise, the court can and oftentimes has to prefer one party's interest to the other party's interest. On page 64, part H, and that is another, I would submit, protection that mortgages can have. His Lordship states that where the financial prospects are evenly balanced with the mortgagee and the mortgagor,
Where are you reading from?
between G and H, the reason is that
In the beginning of the paragraph, it was only an exception so that the power will be exercised against the mortgagee's wishes.
Page 64.
Page 64, yes. So the paragraph starts, I do not accept this proposition. The proposition being that there is this practice that one does not exercise the power if there is a shortfall. And then the protection that Sir Michael Kerr offers is to say that if a mortgagee can show that the prospects are financially are even, let alone that they favor the mortgagee, then in those cases almost never would the court prefer the mortgagor to the mortgagee, but would always accede to the mortgagee's demand. In the later case of Barrett, the same point is described as a tangible benefit. It is said by Mr. Justice Evans Loam that the court will not exercise Section 91 power if it deprives the mortgagee of a tangible benefit that it enjoys. Another significant point about this judgment, because the word exceptional is used both by the judge and in the other cases. What Sir Michael Kerr says is exceptional about this case, that is F. So the exceptional cases are where if the power is exercised, there's going to be a shortfall. The exceptional cases are not the cases where the court orders a sale against the mortgagee's wishes. They are the cases where it does so and that is going to lead to a shortfall. That is what the judge describes as exceptional. And again, in this case, once the unfairness is identified, Sir Donald Nichols did engage in that weighing exercise. She said there's this overwhelming unfairness to Mrs. Palk if she's forced to stay with this property. And then there's this comparative deprivation of rights to the mortgagee, which can be remedied if it decides to buy the property. So there is this weighing exercise that the judge does, albeit I would admit, I would concede that the weighing exercise is not a case where if the balance tilts slightly towards the mortgage or the court goes with the mortgage, or because as the case is made clear, there has to be a disproportionate unfairness prejudice to one side as opposed to the other, well, to the mortgage or as opposed to the mortgagee. So
the unfairness here is your belief that it'll be worth more and that you'll be able to pay off the whole debt and have a bit of money to spare. And that's the unfairness.
But that is the core of the unfairness, my lord, and flows from that number of consequences. That this property is the only asset of this company, and if it is sold at a deficit, it becomes insolvent. It can then be wound up. If it were to have a claim for a breach of duty by the receivers for a sale at an undervalue, itself is it's a well-defined duty that they owe. It has to be limited. It has in front of it an expensive litigation, which it may never be able to make because it'll be wound up because it's an insolvent company. The other unfairness, or the balance is, that's really my ground, but I will submit it now. It is that for this company, it is an all or nothing proposition. It either gets the surplus, a substantial surplus of the asset it owes, or it is left with a debt that it cannot afford and would have to probably go into liquidation. That is the existential threat that the company faces. And on the other side, the mortgagees have not just the benefit of the personal covenant, which is meaningless in this case, but they have the benefit of 2 unlimited guarantees against the directors of the company. At the time, only one of the guarantees was before the judge, so she only knew of the guarantee that Mr. Vitale had given and not his wife also. But she knew of the assets that Mr. Vitale owed, substantial assets. But more importantly, it was shown to the judge that the real prejudice that would be caused to the mortgagee in this case would not be that it is left with none of its debt paid. The realistic prejudice to this respondent would be that 180 days come and go and the property is not sold and the interest goes up. And the answer to that was to show that there's a rental income that comes in and there's been rent that has been retained by the receivers. They have not invested it, they have not used it to pay down the debt. And those figures by themselves would leave a surplus covering both accrued interest by Coutts and Venus in that period. But on top of it, Mr. Vitale had said in his witness statement that I would consider covering the difference. Now, he came up with a different calculation for the interest. In his calculations, it was £30,000. Because of the way in which the rents fall due in chunks, it is larger than that. But because he had substantial assets, these were all options, all protections that could have been given to the mortgagee. The equivalent, not identical by any means, but the equivalent protection that the mortgagee in Park had, meaning it had an option, whereas Mrs. Park had no option. That is where the unfairness, starting from the undervalue, ends. It's not just the undervalue itself, but the consequences that flow from it.
Firstly, you're assuming an undervalue.
Yes.
Is that in your case? And I'm not a commercial lawyer, but if you lend people money on a mortgage and they default, why is it fair to say, and we're not going to let you exercise your rights as a mortgagee, and you've got to be satisfied with something else which you didn't want to rely on, because they don't want to rely on the personal guarantees or on the consideration that any shortfall in interest would be paid. It seems to be the sorts of things that fell into the first half of Polk that Sir Michael Carr was saying was normally the mortgagee is entitled to rely on his right to get the mortgage, the property sold to pay off the debt. Park was different circumstances. So I don't quite understand at the moment why the unfairness to the mortgagee is left out, computed on the basis that there might be unfairness. If there might be, I say there's a bit more money, which
Well, my
is a
lord,
problem that I'm still struggling
I
with.
hope it's not too semantic on my part to say that it's not that there might be unfairness, but that there is unfairness if one considers the risk and the consequences from that risk. And that does go to my second ground. I would summarize what it is now because we are discussing it at the moment. The judge defined unfairness very narrowly. At paragraph 12 of her judgment on page 66. I am starting from the point that says, I accept Mr. Morris's submissions. That the mere fact that the sum realized from the sale is likely to leave a shortfall is not in itself sufficient unfairness to find an order under Section 91. Now that is unimpeachable. The fact that there is a shortfall is not unfair, it is just the way in which calculations add up. It's the second part. There is unfairness, therefore, in this case, only if Mr. Brooks' submissions that the property is likely to be sold at an undervalue are correct. So what the judge required was that it should be proven to her on balance of probabilities that this property was worth £7 million and it was being sold for £5 million.
It's broader, likely to be sold at an undervalue in a way that's meaningful. If it is
Yes, if it's
£5
trivial.
difference, it wouldn't make any difference. The circumstance in which you wrote that sentence clearly involved a situation where you're saying this is worth so much more, the debt will be cleared and I'll have money. So I don't think she can be fairly criticised for it.
Well, my lord, where I would respectfully criticise the judge's reasoning is to say that the only case is one where the appellant proves that there's going to be a sale at an undervalue. Now, there is a conceptual error here. If one accepts that a sale at an undervalue or a sale at a material undervalue is unfairness, why should not a slightly lower likelihood of a sale at an undervalue be a potential unfairness, depending on the other facts of the case? The points that I'm raising being that what makes a sale at an undervalue unfair could make a potential sale at an undervalue unfair if it is less than 50% chance before the judge. So the judge has not been convinced that this is definitely going to be sold at an undervalue, but the judge has been convinced that there is a more than trivial, in fact, a substantial risk that it will be sold at an undervalue. Combined with the consequences of that risk coming into fruition, could create unfairness. The 30% risk that I could walk out of this courtroom today and be hit by a bus is less than 50%, but the consequences are so drastic that they might call for remedies that otherwise would not, if I were not to be hit by a bus, but be hit by a bird, for instance. Why should unfairness be dependent on proving undervalue on the balance of probabilities, and nothing short of that? If the consequences are dire, and if the deprivation or the prejudice to the mortgagee is trivial or quite low, there could be unfairness in allowing that gamble to take place.
You're merging two things. You mean the risk of unfairness with the fact of unfairness.
My lord,
There would only be unfairness if it's sold at a massive undervalue, i.e. it's not the price that they reasonably could get for it. What you're saying is there's risk that might happen. Because of the risk, you might get run over by the 92 bus. Therefore, stop it.
I would perhaps respond to it in the following way. In Park, there was a remote prospect that the property could be sold at a huge surplus, would be a turnover in the market. So in Park, the court was looking at future risks, albeit the risk was skewed the other way around, meaning there was a remote possibility that Mrs. Park would not be prejudiced at all by the sale. But there was a large risk that she would be, because there was quite a speculative move by the mortgagee. So in that case, the court was looking at risk was making a calculation on the risk. It was saying that the mortgagee should not run this risk on the back of Mrs. Park because of the facts of those cases. And by analogy, I would submit that in this case, the respondents...
There was unfairness to Mrs. Park. The interest would be higher. And the only question is whether it would not be unfair, because there was a risk that if it did shoot up, it would actually exceed the amount of the extra interest. But the starting point there was that there was real unfairness.
My lord, the unfairness was not the interest, because even if the property were to be sold as it was ordered to be sold, the interest would have gone up because it would not have paid for the full debt. So she would still be encumbered by this residual interest that keeps compounding. It was about the fact that she was stuck with this property, which she could at least not reduce the principal sum and forever be tied to it. That seemed to have been the unfairness. So it was not the amount of debt. It was the fact that she was being forced to cling on to
the amount of debt on which she was being forced to pay interest. The amount of debt would be less if you were able to sell the property and reduce the debt, and the amount of the interest would be less. That was the problem. And if she wasn't allowed to sell it, the amount of the debt would remain the same and the interest would go up. That was the unfairness. And the risk there was not the risk that she might suffer unfairness. It was the chance that if the property did shoot up in value, the unfairness would be removed or ameliorated. But that's a different thing from what you're saying.
It is different only in the sense that the likelihood in that case was, as matters stood, that she would suffer the unfairness because the property prices would not rise. In this case, at least on the judge's finding, the balance of properties, it was not going to be sold at another value, therefore it was at its proper value. But the point I was making about, so acknowledging that difference, the point I was making about PALC and the way in which it relates to this is that the court was looking at future events and the consequences of allowing those future events to happen. And I also acknowledge that if one has been unable to prove on the balance of probabilities that the property is being sold at an undervalue, one has to have very good other consequences and other factors that make the running of the risk unfair. So to summarize my position, it is allowing the respondents to run the risk of selling this property at the undervalue. That is the unfairness to my client. Because if they're prevented from running this risk and my client were to be allowed to sell it, the potential undervalue would not take place or would be tested out. And as I would say in my third grounds, the mortgagee would be sufficiently protected.
How would the mortgagee, just remind me, going to be protected?
So the mortgagee protected is by the personal guarantees, number one. Number two is the rental income that comes in and covers the arrears of substantial part of the arrears of interest. The accrued 2 quarters, at the time 2 quarters, now it is a lot more, of held up rent that had not been applied to the arrears, or as far as we can say, invested. So there was sum of money sitting there.
So the rent will always be above the interest?
No, it would be slightly below it.
Right.
In the calculations that was before the judge, which was at least not fully scrutinized, although I made submissions about it in my skeleton argument and later, on supplemental bundle 297. We can see that there are 2 blue and green boxes on top. If you're, this is a color, then there are 3 boxes blue and 3 boxes green below them. Now that was my approximate calculation of monthly and quarterly interest. Of course, it's inaccurate for 2 reasons. One is that Coutts's interest doesn't accrue monthly, but it accrues quarterly, and also because they compound.
But the short question is, will the rent cover the interest? But if not, they're not getting their interest by the rent.
So the answer to that, my lord, is it will not be covered. And that is shown by the pink box at the bottom. Again, in approximate ways, I tried before the judge to show what happens from the month following the hearing. One can see the quarter of rents falling due on the left-hand side and the approximate interest for Coutts and Venus falling on the other side. And one comes up with a deficit of £154,000. However, against that is the sum of £150,000 of rent that was just sitting there, old rent, accrued in the previous 2 quarters that was not being used. And the appellant's submission was that if you're neither applying that to reduce the interest or to reduce the arrears or to invest it at anyway the rate at which interest is accruing, which is 3% per month, at least for Venus, then it is right to use that to apply it to future interest. But Mr. Vitale had said in his witness statement that he offered to cover this difference, even if one didn't apply the old rent to extinguish it. And the judge had before her, and the respondents had, evidence of his means that far exceed not just the sum of £154,000, meaning his assets, but exceed any deficit that might be due to Venus. The only thing about that, those means are that they are property investments, so they cannot be quickly realized, but they are there. So that was the way in which, my lord, I submitted that the comparative prejudice to the mortgagors is relatively trivial to what I described as the all or nothing situation that the appellant faces. I would describe briefly the findings in Barrett and Halifax, if I may. It is tab 6. This was another case of a successful Section 91 application.
It's considered, isn't it, in Chatham, Gloucester?
Yes.
Mm-hmm.
Lord Justice Phillips does not so much criticise, but contemplates about the consequences that it might have. And I would submit later, not consequences in the abstract, but specifically to do with possession orders and how homeowners, especially mortgagors, might make perhaps unmeritorious Section 91 applications and then try to get an adjournment of a possession or a suspended possession order on the back of it.
Yes, and
No.
Lord Justice Millett says he's not sure it's right.
Yes, I mean, Lord Justice goes further.
Mm-hmm.
The relevant ratio of the decision is that not only did the judge order a sale of the property against the wishes of the mortgagee, where there was going to be a shortfall, a certain shortfall, but that the court did so when the mortgagee was taking active steps to repossess and sell. So unlike Park, it didn't propose to sit on the property, it was actually trying to sell it. But the mortgagor had found what he considered a better offer and wanted to sell it there and then, so the court made the order. There are 2 crucial bits that come out of this decision in my submission. Page 90 of the authorities bundle.
Yes.
There are no, yes, the first line, red line, is where his lordship talks about not depriving a mortgagee of a tangible benefit. Now that is, I would submit, protection, and that prevents Section 91 from becoming an open-ended attempt by anyone who's got any objection or any issue to make these applications. Then there is the penultimate paragraph and the one above it, which I submit, in addition to the next paragraph, is the weighing exercise. The judge's conclusion is in the next page, where he says, I am left therefore with a case which on the evidence before me there is no discernible advantage to the building society in refusing to allow a sale. So I would state that Barrett stands for the proposition, clearly, even if it didn't come out of Park, that the court is willing, in the right circumstances, to make an order for sale against the wishes of a mortgagee who is taking itself steps to sell the property. And then I turn to Cheltenham and Gloucester, which is the next section.
And the only reason why the Building Society here didn't want to agree to the sale was they've got a policy of not allowing
Yes.
the mortgagors to sell. They want to do it themselves. So that was the only issue there.
So that was, one could say, another extreme case. In fact, the authorities' boundary is filled with extreme cases on both sides, and one could say that the limits of the law are only properly tested when a factually difficult case like this comes before the court. And Cheltenham and Gloucester was itself a very extreme case. Now, I should set out from the beginning that it was not a case about Section 91. It was a case about the application of Section 36 of the Administration of Justice Act 1970, which grants the court a discretion to suspend or adjourn a possession order or to make it subject to conditions on the basis, to put it in a summary way, on the basis that it is satisfied that by doing so the mortgage would be paid off or any arrears would be cleared off. The extreme facts are as follows: that there were many defaults by the mortgagor, and just as the final possession order was about to be made, the mortgagor had proposed to sell the property to a charity that would have let it back to the mortgagor, and was proposing to do so at a 30% discount, meaning 30% below the market value. So therefore, this was the reverse of this case, where the mortgagor wanted to sell it at a low price and the mortgagee was saying that it is actually worth a lot more. And in that case, it was certain, this is important both for Section 36 purposes and distinguish this case, it was certain in that case, like the previous two cases, that there will be a deficit if a Section 91 order is made. I should emphasize here and perhaps throughout that for the reasons already covered, this case is not strictly like the cases that we have been covering. In all the previous cases, the making of a Section 91 order was certain to lead into a deficit in the short form. This is a case where on the mortgagor's evidence, if a Section 91 order is made, there'll be a huge surplus and everyone will be happy by the end of it. The ratio of the decision by Lord Justice Phillips, after covering the ratio in Park in page 96, where his lordship does note that in Park it was not an issue as to whether the mortgagee wanted to sell it. That's in section H of the page. In the next page, page 97, his lordship discusses the case of Barrett. And it's page 98. Where he describes or refers to the far-reaching consequences of Barrett's case. Now, I would submit that what his lordship has in mind is the consequences that a Barrett's-like application would have on orders for possession. That is borne out by the next sentence. And further on, where he states there will be a danger if the mortgagee does not obtain possession, the mortgagor will delay the realization of the property by seeking too high a price.
What can we really get out of this? This is just general observations about Barrett.
Well, my lord, the point that I'm trying to infer from this is that the concerns that Lord Justice Phillips had about Barrett was about the effect it would have on its being used to delay possession of the property. So it was not directly about whether Section 91 should be ordered or not, whether a mortgagee is taking steps to sell. So the point I'm driving from this is that there is no authority in Cheltenham and Gloucester unlike what the judge stated and what Lord Justice Millett
The negative
states.
point. It doesn't show you should sell. It simply points out some of the dangers,
Yes.
but they aren't the dangers you say in this case.
And in fact, the Lord Justice Phillips himself says that judges are quite familiar with those sorts of delaying cases and they can deal with it. So it's not quite clear whether Lord Justice Phillips is concerned about Barrett or whether his lordship is essentially saying this is the solution to that by stating, or rather reasserting, that Section 36 suspension or adjournment of possession only applies where a court is satisfied that the mortgage should be cleared off. To be cleared off either by a Section 91 order for sale or by other means. So that is on page 100, B to D. That really is the ratio. So, yes. A mortgagor seeking relief in the circumstances of Park's case, meaning circumstances where there will be a deficit at the end, is unable to invoke any statutory power to suspend the mortgagee's right to enter into possession. That is what the case is about. Further below, his lordship was referred by counsel to the court's inherent power to adjourn possession proceedings, and he was urged by counsel to exercise that power as opposed to Section 36 power. On the next page, page 101, paragraph E, where the paragraph starts, I recognize the principle of inherent jurisdiction of the court. There, his lordship is referring to the inherent jurisdiction to adjourn. Why do I underline this? It is because Mr. Justice Morgan, in a later case, refers to this line in support of the proposition that Section 91 will not be used where the mortgagee is taking active steps, or that, in his words, it would be inappropriate to use it where a mortgagee is taking active steps to sell. But as I have submitted, all of this is about Section 36 or other powers to adjourn a possession proceedings. Admittedly, it is the judgment of Lord Justice Millett, the conclusion of Lord Justice Millett, where one finds perhaps the most explicit criticism of Barrett's case and the most explicit expression of reluctance about where the court would come in to intervene. His lordship identifies two cumulative factors at the bottom of that page in the way in which he distinguishes Park. He states that Park does not support the making of a Section 91 order, where the mortgagee is taking active steps to obtain possession and enforce the security by sale. Still less does it support the giving of conduct of sale to a mortgagor in the case where there is negative equity. Perhaps a crucial element later, so that it is the mortgagee who is likely to have a greater incentive to obtain the best price. Therefore, I query whether a relevant factor is that where there is negative equity, the mortgagee has a higher incentive to obtain a better price, and that is one of the reasons that the court leaves it to the mortgagee. I would remind myself that all of this is being said in the context of residential possession, where oftentimes, for natural reasons, homeowners have an incentive to delay matters because they want to stay in the property. It doesn't apply to a commercial property case with the same force. As to the first point by Lord Justice Millett, I would submit that that is clearly not supported by Park. Park is expressed in very broad terms and is expressed to cover or to apply to any instance where a mortgagee insists on its rights and intends to disagree based on its rights. Now, that should include the right to sell as well as the right to appoint receivers. As to the second point in Lord Justice Millett's dictum, about not giving conduct of sale to a mortgagor where there is negative equity, I would make 2 points. The first is that this is not quite the same case, unlike those other cases where negative equity was certain. But the second point is that, again, it is not supported by Park. One engages in that exercise, identify the unfairness, the prejudice to the mortgagor if the order for sale is made. And the fact that there is negative equity would be a factor, but that's not the decisive factor. So one should not fetter this question like that. There's another case from this court on tab 9, Lord Justice Neuberger. I will deal with it briefly because although it covers these cases up to the ones that we have looked at, it was in front of itself was obiter because it was an appeal from a possession order. It was not argued by both sides, and the judge was therefore quite cautious in the conclusions that he made.
It's an application for permission.
It is the actual appeal itself, my lord.
It is the actual appeal, is it?
Yes, at the end of the judgment, this is application for permission to be refused. Apologize. Yes, it's paragraph 5. It's the appeal from a possession order.
It's originally listed according to paragraph 1 as an application.
Yes, I'm grateful to my learned friends.
It then seems to become more to do with a stay. Yeah.
Well, my lord, what happened is that they were appealing from the grant of a possession order, saying it should not have been made. As his lordship sets out, the submissions evolve, and once it becomes clear that this section 91 exists through the judge's own research, it becomes more appropriate by the end to stay the execution of the order pending the making of an application under section 91 to the court. That is the outcome. The facts are again fairly extreme in the sense that there was a surplus in the property at the time, undisputed surplus in the property, just about. And the mortgagors had said that they had found a purchaser, although they had had a history of not quite going ahead with the sale.
So this is actually just authority dealing with the grant of a stay of execution on condition that an application to section 91 is made. That's
Yes,
all it decides.
It's obiter, like Cheltenham, but it discusses page 149, judgment of Lord Justice Phillips and Lord Justice Millett. And its tentative conclusion is that the court does have potentially jurisdiction to order a sale where there is opposition from the mortgagee and the mortgagee is taking its own steps to sell. That is really what this case or the obiter dictum are. They don't talk about deficit because it's a surplus case, but Lord Justice Neuberger's reading of those two judgments in Cheltenham Gloucester are that at the very least, where there is a surplus, the court can order a sale in favour of the mortgagor, even where the mortgagee opposes it and wants to sell it itself. The next case is a High Court case. His Honour Judge David Cook sitting as a High Court judge, tab 10. It was a last-ditch Section 91 application to order the mortgagee to sell the property at a certain price. And it was made just before the eviction of the homeowners. The claim was refused. The order for sale was, or the application was ambiguous and it was not quite clear what it was seeking. It seemed by the end of it to be seeking a sale to the mortgagor's friends. The point at which the claim failed was that the claimants had failed to show any unfairness. They had failed to show any undervalue, they had failed to show any prejudice. They had just sought this order, which the judge does explicitly say he suspects was made for delaying tactics, to sell it to these unidentified friends. But the point at which it failed was that it failed because no unfairness was shown. But the judge helpfully reviews the authorities at page 161. He deals with park. And I would submit correctly states that in the so-called exceptional case where there is going to be a deficit, prima facie, the mortgagee's wishes prevail, and that is a correct view of the court, of the judge, of the authorities. Unless, and that's in the next paragraph, next page, unless what the judge calls unfairness or prejudice can be shown to follow from allowing the mortgagee to proceed. Now, I would submit that is the correct summary of Park, and there is a correct summary or interpretation of Cheltenham at paragraph 22. Setting out the dictum of Lord Justice Phillips, the judge states that what those remarks mean is that the court should be very cautious and scrutinize potential prejudice or unfairness quite closely in cases where there's going to be a shortfall, especially because oftentimes there is going to be an ulterior motive behind Section 91 claim. And in paragraph 24, he summarizes what he takes to be the principles. I would not review them, but that's a useful reference. And I would submit that they are correct. Prima facie, the mortgagee has the right, unless the mortgagor shows unfairness and can satisfy the court there would not be a tangible prejudice to the mortgagee if an order is made. Finally, Natwest and Hunter, which is the next step, another extreme case whose outcome one could say was inevitable. Section 91 claim in circumstances where the mortgagor had entered into a contract himself to sell the property, whilst the receivers had entered into another contract to sell the property. So there were two potentially enforceable contracts. The judge considers the merits of each contract first and comes to the conclusion that the receiver's contract is in any event better than the mortgagor's contract. It's a more advantageous sale, it's more certain. And then the judge then looks at the authorities, and that is where this interpretation of Cheltenham comes from. It is on paragraph 74. The first sentence. For the reasons stated before, I would say that is the wrong reading of Lord Justice Phillips' remarks. And the part that has been cited is the part where he's discussing the inherent jurisdiction to grant an adjournment to possession claim. The point on which the case is decided, putting aside the fact that the receiver's contract sale was better than the mortgagor's, which by itself probably would have been decisive, is on page 78. The crucial bit was that to make another under Section 91 would have forced the receivers, and therefore Mr. Hunter himself, to breach the contract of sale entered into with the independent third party, with drastic consequences. And of course, the court would never make such an order in those circumstances. So that is the ratio of Hunter. It is not so much about the fact that the mortgagees were actively selling, but that they had sold the property. So for those reasons, the judge did limit her inquiry, or by talking about exceptionality, failed to look at unfairness. And as I stated under my ground, which has been substantially covered, therefore I'll just summarize what it was. The judge only asked herself, there can be one instance of unfairness, and that is if the property is sold at an undervalue on the best of probabilities. In coming to that conclusion, now of course, my lady and my lords, if you, after my submissions, yourself come to the conclusion that this property will be sold at an undervalue on the bounds of probabilities, I would invite you to make that finding if the judge was plainly wrong. But insofar as the judge came to that conclusion, she
how can we find, this is a Part 8 claim, how can we find that that a sale at 5 million is a sale at an undervalue? How can we do that?
Oh, my lord, both parties agreed that this was not a valuation dispute in the sense that we were trying to refute the credibility of one another's evidence. So in that sense, the judge was never tasked with it, nor invited
But
to.
we would have to, because you've got one man who says it's 7 million, you've got another 2 men or women saying it's 5 million. So we have to decide which one of those is right. You can't possibly do that, can you, on a Part 8 application? Or is that what happens nowadays?
Perhaps one could say it can be done where it does not require cross-examination. There was one expert evidence, the others were red book valuations on which the parties were indirectly relying. And as I said it earlier, the receiver's case was not that we say this is the value, but that we are following advice, we are doing everything properly. There is nothing really to see here. But in order not to distract the court with that more ambitious case, it was just a remark on the side, if you really are quite convinced by my submissions on the valuation. The judge, in posing that narrow question about unfairness, then engages in really no way, as one can see, because it is paragraph 12 to 17 of the judgment, where she deals with the undervalued point. So paragraph 12 poses the question. Paragraph 14 to 17 deals with the evidence. And paragraph 17 relies upon, I would say this is an obviously non-credible sort of evidence on the remarks made by the potential purchasers to the receivers about how the value of the property is maybe too high. Well, I never know of a commercial purchaser who goes to receivers and says, maybe it is quite cheap, would you like to raise the price a little bit? But based on that treatment of the evidence, she failed to see that, as I stated earlier, even on the receiver's own evidence, this was, at the very least, a real risk that would be an undervalue. The question really is, would it be an undervalue of £1 million, £2 million, or just £500,000? But even on the receiver's own evidence, she should have concluded that they were selling it at below the expectation. And then if she had looked at the expert report, she would have concluded that no great reliance can be made on the fact that offers that have been received do not exceed £5 million.
So that was an evaluation of the evidence as it stood before her, that she could not have reached, you say?
Yes.
Reasonably have reached. Okay.
The conclusion that she should have reached, having asked the question about the unfairness, was that at the very least there was a real risk. And I do keep in mind your lordship's remarks about the difference between there being a risk and whether a risk is unfairness. Well, my case is that a risk can be an unfairness if the consequences are quite drastic, because then the question is it fair to allow one party to take a risk at the expense of the other? The question being, what if it is true? Would it not be so bad that we should not allow this risk to be run?
There is a difference between a situation where the alleged unfairness is a sale at an undervalue and a situation where the alleged unfairness is the risk of a sale at some undervalue. And it's the latter, I think, you're saying is the unfairness here. So if anyone can turn up in a court and show that there is a risk that the evidence relied on might be wrong, there might be an undervalue, that is the basis for saying it should be the mortgagor, not the mortgagee who conducts the sale. That, I think, is the logic of the submission.
Yes, my lord, that's the logic of the submission. However, the way in which I would reduce its sharpness is to say that one looks at the facts of a case. And if I had merely gone up before the judge and said there is a real risk of an undervalue, without actually looking at the evidence and what I meant by the real risk. Because a real risk is just a label that one puts on the way in which the facts are.
I agree that we want to avoid labels.
Yes.
That is why you want to describe the state of affairs, the underlying state of affairs. And there are two underlying state of affairs at issue. One is the price would be sold at 5 million and it's worth 7. The second state of affairs is there's a risk they might have got more than 5 million and might have been closer to 7. And you're dealing with the second. You're not saying unfairness because you've not asked the judge to decide that there's a sales and undervalue. You can only be saying that it's sufficient to justify an exercise of discretion, or the judge was wrong not to regard it as sufficient to exercise discretion, if there was a risk that a sale might be at an undervalue of some amount.
Yes, my lord, that was my case. And what I would have told the judge, in fact, what I submitted to the judge, was that one takes that fact, combines it with other facts to which there is no regard had in the judgment, perhaps in the judge's mind, but there is no regard, because the moment that the judge comes to the conclusion that there is no sale at an undervalue, the question of unfairness ends. But my submissions to the judge were, one looks at the risk of undervalue, combines it with its effect on both parties, of it's allowing to happen and not allowing to happen. And that is when it is just and equitable to exercise it. If, for instance, this property did not have substantial rental income, that would have made it less likely to exercise. If there had been no guarantees in place against people of substantial assets, well, that would have counted against the mortgagor, and then a mere risk would not have been that important. But because there was this risk, because the difference was between a large surplus and a deficit, not between a small surplus and a small deficit, and because the mortgagor could afford to allow this possibility of its being worth more to play out and not be prejudiced by it substantially, that is where the unfairness comes. And that is where, using Ms. Justice Kerr's words, trying to be fair to both parties, but having to prefer one party's interest over the others, the judge could safely have preferred my client's interest over the mortgagee's immediate interests, with the thought that in the long term, well, by the long term I mean at the end of a 180-day or a 90-day sale period, the mortgagee would not be worse off. That therefore is the overall exercise of judgment that follows from that first point. That is just a starting point. The real risk is just a starting point.
I think that probably takes you to your third ground.
That indeed covers my third ground. The third ground, which the judge only dealt with on a very narrow basis, which was if a sale does not take place, well, the mortgagee has to resell it and there'll be expenses in that.
And that's paragraph 18.
That is paragraph 18. And my response to that, in the way which the judge erred, was first of all, the likelihood of the sale not taking place in a commercial case is much lower than a residential case. In a residential case, probably it's a real danger that a mortgagor, a homeowner, is just going to delay, has high ambitions, is going to sit. But for a commercial mortgagor, it's more or less all about the pounds and the pennies. Therefore, it is not going to sit for 180 days and allow the period of sale to come to an end for arrears to accrue. So that by itself was a remote risk. And the costs of a new attempt at sale themselves were neither before her nor given to her by way of an example. And no one knows what those costs are, whether they are just merely in the low thousands of pounds, in which case they are quite trivial against the hundreds of thousands of pounds that is at stake in this case. As I said in my skeleton argument, the real prejudice that the judge should have considered, had an order been made, would have been the extra deficit. The extra accrued interest. And the appellant offered to the judge, and I recited it earlier, the solutions put forward by my client, none of which were as good as putting the money up front into the court. But they were the second best, which was there's rental income that reduces it, there's this other part of rent that is sitting there that could be applied. The judge did not really pay any regard to that. And secondly, that you have recourse to directors and the owners' full assets. Now, that was fortified by an offer of an undertaking that did come in my reply, but that was in response to a submission by my learned friend. Now, an undertaking by itself doesn't probably take the respondents that much further ahead than an unlimited guarantee. That's why it only came in reply. And in my opening submissions, as well as in the claim itself, I did expressly remind the judge that she was not bound to make the order in the draft form 180 days. Other options were open to her. She could impose a minimum sale price or a short period of sale. She did not consider those, but those all are the tools available before the court in a Section 91 claim to reduce the prejudice to the mortgagee when it makes settlements. Now, those conclude my submissions on the main appeal. I'm afraid this appeal might take more than half a day. I apologize for that. But the point about the expert report is itself quite short. Having seen the facts of this case, at the very start.
And the point about the expert report is that the evidence in relation to actual value was already in. It was the issue about the approach to marketing.
Yes, precisely, my lady. And in fact, as the judge's own judgment proved by the end, the view one takes about the offers received and how they relate to valuation is one of the elements or one of the issues that go into resolving the proceedings. Not having an expert's view on how much weight to put or what to make of those offers received and whether they were indicative of the inherent value of the property, therefore would have been something that would have been reasonably required and would have assisted the judge in weighing that evidence.
When did you know that the property was going to be marketed in a way that the respondents, receivers, proposed to market it?
The first indication of its price came in October 2024. September, October.
You knew that it was going to be marketed at a price of in excess of?
Yes, but there was no evidence provided of the sales strategy or the marketing until after the evidence in response. So as part of the pre-action correspondence, the appellant wrote to the receivers saying, could you explain to me what is this based on? And the receivers took the view that it was best in circumstances not to disclose the advice on which they were relying. So their advice only came in late December as part of the evidence that they put in.
So in December 2024, you knew the strategy?
Yes, the details of the strategy.
Just remind me of the facts. When did you apply to the commission to put in evidence?
We applied to put in permission to rely upon the expert report on the 18th of February, but the expert report itself was filed in along with the reply.
But you didn't have permission at that stage to rely
No,
on
no,
it.
we did not have permission.
So it's the 18th of February, the relevant date.
Apologies.
It's the 18th of February, the relevant date then.
Well, my lord, I will submit that it is earlier. What happened is that upon filing and service of the expert report, Mr. Adamson, the solicitor for the respondent, wrote and said that you do not have any permission to rely upon it and therefore no weight should be given to it. He did not express any substantive objection to the report itself. And that led my client to the view that all that was needed was to put in the application. And therefore the application was made about a week before the hearing. So there was a delay between January.
I thought you had to get permission to rely on it. Whether somebody objects or not, don't you have to get permission to rely on it?
Yes, my lord. No, there is no question that there has to be permission. It was just a question of whether it was expected that there would be an opposition to it and therefore there was a need, for instance, for an application hearing. The objections given by Mr. Adamson on...
You thought that given the response that you got, that it was okay to apply at the hearing rather than to apply earlier?
Yes, my lady. The view taken was that it is therefore a procedural question. Of course, the permission has to be obtained, but it could be obtained at the hearing. Now, it was not anticipated at the time that there would be an injunction hearing. The injunction hearing was had. The issue was not raised then. And the second reason that it was only sought at the hearing was that the judge was not being invited to, as I say, make a finding of fact or to prefer evidence, but it was to enable my client in making submissions to refer to the expert report and therefore to invite the judge to treat the evidence in a certain way. Without that expert report, my learned friend could refer to the marketing evidence and say, look, my lady, it has obtained only interest in the sum of £5 million. That must be an indication about what the property's worth is. Whereas I could not refer to the expert report and say, my lady, you can take the view from this expert report that you should treat with caution those offers received. So that was the purpose of the expert report. It was not in the classic sense whether, for instance, the latent medical condition has been caused by this factor or that factor.
I'm wondering what is a piece of paper which has views expressed by Mr. Ferris, and you want the judge to read that piece of paper for a purpose.
Yes.
And just remind me what the purpose of reading a piece of paper is.
The purpose was to treat with caution the offers received as indication of the property's inherent value, rather than just as a consequence of the receiver's specific marketing strategy.
So it's to cast doubt on the evidence of the respondents experts or valuers.
Not to cast doubt, but to interpret them, give them proper weight, to understand them in the context.
It is evidence then.
Yes, but it wasn't to reject them or to do any such thing. But yes, my lord, I should not label that point. It was put to evidential purposes.
You made mention of the 18th of February. I'm just looking at your skeleton, and that is the expert application was filed and served, but actually you'd made the Ferris report, if I can call it that, available on the 10th of January.
Yes. I can acknowledge a potential criticism that if an application is going to be made, it should be made as soon as possible. I can see that. Against that, either to offset it perhaps partially, if not fully, to say that because of Ms Adamson's response, it suggests it was viewed as being merely a procedural issue, that you have not made an application. So the answer was, well, then we'll make an application if that's your only issue. That is why it came so late. The judge did not so much rely upon that, although she does say in her judgment, paragraph 2, that she put some weight or gave some consideration to the fact that the respondents would have wanted to cross-examine Mr. Ferris given the chance. Although again, it was never said what point the disagreement was about the report, but maybe the inherent right to cross-examine and test. But the main point on which the judge made her decision was on whether she deemed it reasonably required to dispose of the proceedings, relying upon that. And as her judgment itself shows, it would have been reasonably required, because it would have given her an alternative view about what these offers are. So that is my submission on the expert part. In the judge's mind was the possibility, which must be in this court's mind and in the mind of every property developer and receiver, that if a claim like this is allowed to go ahead, then every property developer who has got this agreement will be lining up in front of the court trying to get control sale themselves. As I've suggested, that itself would not be justified even if my client succeeds, because it is not just the undervalue, but the difference and the consequences. That's what makes this a case where Section 91 can be safely exercised. Unless there's any further matter on which I can assist you.
No, thank you very much indeed. Mr. Morris.
My lady, my lord, good afternoon.
Good afternoon.
Does it make sense if I have 10 minutes before lunch now and then?
I think it does. Just plough on.
The essential starting point of my submission is to frame exactly the question that the judge was asked to answer, or the exercise of discretion that she was asked to make. And in my submission, that is very simple. She was asked whether she should exercise her discretion to make the order sought, taking into account the material which was in front of her. She was also asked by the appellant to make a finding that on the balance of probabilities, based on that material, there was this real risk of a sale at an undervalue. And of course, as my Lord Justice Lewis put to my learned friend a few moments ago, because the appellant had chosen to issue a Part 8 claim, the judge was asked to do this without the benefit of hearing any live evidence from factual or indeed any expert witnesses. And it might be thought that that presented the appellant with something of an uphill struggle below in persuading the judge to prefer its own case over that of the receivers. Because, as the court will appreciate, this was not a case like Pulk, where the prejudice was accepted, was admitted. The facts in Pulk were very obvious. It was argued purely as a matter of principle. But that was not the case here, because the judge was presented with witness statement from very experienced receivers who are professional office holders, making clear that they well understood their professional duties and making clear with lots of documentation in support that they considered that they had discharged those duties. So, unsurprisingly, perhaps, the judge held on the evidence before her, just on the paper, that she was not satisfied on the balance of probabilities that there was a real risk of a sale at an undervalue. So just turning back to the question, the judge, in essence, she was faced with a choice between two imperfect solutions. She had, on the one hand, a commercial mortgagor in default saying that they could get a higher price if they had conducted the sale, and on the other hand, she had duly appointed professional receivers relying upon their contractual entitlement and saying, we want to sell at the time and in the manner of our choosing in order to redeem the appellant's indebtedness now. And that engages something that was said by Sir Michael Kerr in Polk. If I can ask your ladyship and your lordships to turn it up. So that is behind tab 4 in the authorities bundle. And specifically on page 63, at C, Sir Michael Kerr asked himself the question, are there then any limits to the proper exercise of the court's discretion? And went on to say, I'll just pause while my Lord Justice Lewis turns up the right page.
Sorry, yeah, I don't know.
So it's page 63 at C. He says, the requirement of fairness to both sides goes without saying, but equality in giving effect to their wishes is manifestly impossible, since the plaintiffs request a sale and the company opposes it. The court must decide between them on the basis of what is just in all the circumstances. This will mean giving preference to the commercial interests of one over the other, but there is nothing new in that. And the reason that I draw attention to that is because it is a nice jumping off point into the authorities on the approach that should be taken by an appellate court reviewing that sort of a decision to be made by the judge. And in my submission, it takes us straight into the territory of the House of Lords decision in G and G. That is behind tab 3 in the authorities bundle. So this was a 1985 House of Lords decision, and it was a family case with very sad facts, as often the case. The father was a widower, he had 2 children, he'd married a mother with 3 children, and they had 2 more children, D and N. The relationship sadly broke down, and the mother left taking her 3 children. D and N remained with the father, the mother applied for custody of D and N, and the judge heard all the evidence and held that the children were better looked after in the father's home. So in other words, contrary to the mother's application, D and N remained with the father. The mother appealed, the Court of Appeal dismissed the appeal. There was a further appeal to the House of Lords, and the question before the House of Lords was whether the Court of Appeal had correctly stated the principle upon which an appellate court should proceed when reviewing a decision of a judge in the exercise of a discretion involving the welfare of children. And if we turn to page, internal page 651 of the judgment, which is on page 45 of the authorities bundle, we find a speech of Lord Fraser. And what he begins by doing between B and C is by rejecting the submission that special principles apply when the discretion is exercised in the context of custody of children. And what he then said is that the main reason that in most of these cases there is no right answer. All practicable answers are to some extent unsatisfactory and therefore to some extent wrong. And the best that can be done is to find an answer that is reasonably satisfactory. It is comparatively seldom that the Court of Appeal, even if it would itself have preferred a different answer, can say that the judge's decision was wrong. And unless it can say so, it will leave the decision undisturbed. The limited role of the Court of Appeal in such cases was explained by Lord Justice Cumming-Bruce in Clark Hunter Newcombe, 1982, another family case, where he said there was not really a right solution, two alternative wrong solutions. The problem of the judge was to appreciate the factors pointing in each direction, so on and so forth. About halfway through the quoted passage, he then says, I am sitting in the Court of Appeal deciding a quite different question. Has it been shown that the judge to whom Parliament has confided the exercise of discretion plainly got the wrong answer? I emphasise the word plainly. In spite of the efforts of counsel, the answer to that question clearly must be that the judge has not been shown plainly to have got it wrong.
Mr. Ross, I don't think there's anything between you here. You agree, don't you,
My lady,
that this is an exercise of discretion and that when we're looking at it, we've got to conclude it was plainly wrong. There was an error, serious error of law. There were factors which ought to have been taken account of, which weren't. There were factors which were taken account of, which shouldn't have been. All those things with which we're very familiar.
My lady, I apologise, except of course the court is familiar. Nonetheless, I wanted just to try to illuminate exactly what the content of that test is. And I appreciate what your ladyship's just put to me, but with further apology, if I might just show a more recent judgment of the Court of Appeal in Ray's Sprint Room, which is behind the...
Yes, with which we're very familiar.
So, my lady, all I was going to draw attention to was the quotation from Lord Justice Lewison's judgment in McGrady and McGrady, and
Yes.
that is page 261, to draw attention in particular to the caution against island hopping.
Yes.
Because, my lady...
I don't think that was McGrady, I think that was fine.
Sorry, my lord, yes.
Yes, it was.
Yes, I'm sorry, it was Farge UK Limited in Chobani. And that is paragraph 78 of the Sprint Room decision, from which Lord Justice Lewison extracted, and in which he extracted...
We do apply these principles day in, day out.
My lord, I'm sorry, it appears I am trying to teach the bench to suck eggs. But in my submission, the trawl through the evidence, the selective trawl through the evidence, which my learned friend invited the court
It's
to do...
fairly comprehensive.
Well, comprehensive, perhaps, my lord, but it was nonetheless in my submission in the nature of island hopping, because of course, as we are reminded, paragraph 77 of Sprint Room, lurking behind the printed words of a judicial decision are all of the nuances, all of the things on the judge's mind, which might not have made it into the decision, but nonetheless could be assumed to have been taken into account. So that is all I will say about the test. Subject to one point of reply to what Mr. Brooks said. Drawing on, I think, Ray Graham, he suggested that, well, he drew attention to the fact there were two ends of a spectrum and that this case lay somewhere in the middle of the spectrum so that the court might be more ready to intervene. For what it's worth, I don't accept that characterisation in my submission. It's firmly at the vaguer end, but I don't think it makes any difference because the test is still, as my lady, Lady Justice Asplin put it to me earlier, which is there some identifiable fundamental flaw in the logic? Has something been taken into account that oughtn't to have been taken into account, and so forth. So that is the question with which this court, or the question that this court, of course, needs to apply, which is different from that asked by the judge below. Having made those introductory remarks, I was then just going to jump straight in to deal with the grounds.
And so I think it's probably best that we start again at 2. Thank you.
Court rise of fable.